Number 1 is Kumar Kumar.
Surely constituted.
इसमें कदम 3 को कब फाइल की अभी फाइल कर सेक्शन नहीं आया आपका अर्लियर एप्लीकेशन पे are you adopting adoption कर लीजिए since there is no one present in the applicant list after 2 weeks. The victim has already been served. I mean, intimated.
Your number 2 is uniform, but
You had said that it has become infructuous.
Yes, it's my mistake.
It has not been settled yet.
It's a still success.
Who was for the other side?
State. State for the
It was the section 14 order.
yes, it is section 14 order has been dismissed.
To dismiss.
This case number, the DM has traveled beyond the fiction travel into the merits of the case and dismissed it. That order has been filed as a P2 number, whereas in page number 20 number, in second paragraph, it's from the 7th line. अनावेदक का वर्तमान में ऋण राशि अभी बकाया है। यहाँ महत्वपूर्ण प्रकरण में अनावेदक क्रमांक 3 बहुत हो चुके हैं। अनावेदक क्रमांक 3 कैंसर की बीमारी से पीड़ित होने से संबंध दस्तावेजों से पुष्ट होता है। अनावेदक का ऋण 183 रुपये बकाया हुआ है और एवज में बंधक संपत्ति ज्यादा मूल्य के नैसर्गिक न्याय के दृष्टिगत एवं मानवीय आधारों पर नैसर्गिक न्याय और दृष्टिगत एवं मानवीय आधारों के आधार पर आवेदन पत्र स्वीकार किया जाना उचित है।
This IA that you have filed is supported by affidavit of the petitioner.
Affidavit of mine.
No. Petitioner.
No. That application has been filed with supporting what affidavit myself.
Yourself. It is for the petitioner to tell us whether it's actually become infructuous or not.
I know actually it's similar to
Let him come forward and also say, file an affidavit of the petitioner.
the petition is purely my mistake because they have not similar case था उसमें उनका इंस्ट्रक्शन है तो वो नंबर टैली नहीं हो पाया उस कारण से बिटवा था दूसरी पिटीशन से हमने उसकी एप्लीकेशन फाइल की वो उस नंबर के साथ
All right, then we'll just be case with this IA for restoration file. IA for recalling of the order, final order dated so and so, by which the WP so and so had been dismissed as having rendered infructuous based on the statement made by the counsel for the petition. Next one. The said application for recall is duly supported by the affidavit of the counsel or the petitioner in WP so and so. Contains that the cause raised in WP so and so had not become. Next, accordingly, IA so and so is allowed. WP so and so restored to its original number to be listed in the next week. Next week.
number 3, Gaurav Sharma.
Embarrassing. Modification.
Of the letter by the first February, the most mention is Sapai wala. Instead, the place is mentioned in except number. It had 3 and 6, the post. Except वाणिज्य विभाग में CCTC commercial come ticket that's the post level. It is in question in the petition one.
Appointment to the post of
CCTC commercial come ticket clerk.
CCTC.
Two places in the order the post.
The para 3 and para 6.
Yes, sir.
Can you show us from the record?
Well, extra A1 internal page 12.
Hello. Otherwise, OA has me.
Well, please spelling the book here.
You must have filed the OA copy of it.
Yes, sir.
That was P1, P2 क्या था?
Just order rejected by the order.
इसमें है commercial ticket.
Measure P6.
Right, इसमें लिखिए that ये who was appearing for the other side? The main case. Yadav was there. Is he there present in the court? आपके OA में भी सफाई वाला ही लिखा है. That is the problem. How do we?
Order was approved. Actually, here was
Have you served a copy on Mr. Yadav? No, Mr. Yadav was appearing last time. So it will be convenient for us that if notice is given to him. Mr. Yadav आए हैं क्या? अच्छा. कल लगाना पड़ेगा. All right, लिखिए इसमें the IF for yes one so a modification of the order, final order passed and so and so. It's filed on the ground that is filed with the prayer that the expression safai wala found in the said order, the modification in paragraph 3 and 6 be substituted with CCTC, commercial clerk, commercial come ticket clerk. Next part. After having gone through the record, it appears that though the petitioner had wrongly mentioned the relevant post as Safai Wala in his OA, but the cause raised is pertaining to the appointment to the post of the CCTC. Next part. Therefore, this court deems it appropriate to modify the order under the review the extent of substituting. So CCTC in place of full form repayments. 5 found in paragraph 3 and 6 of the order under. Remaining part of the order shall remain intact, disposed of.
Number 4 with corrected matter, the Siddharth Asur Shukla.
Going for April. Any interim order? As per क्या नाम आपका? हाँ? Ishant Ignat. On behalf of the petitioner prays for adjournment since the arguing counsel is on his legs before another court. Just after 2 weeks.
Number 5, the Amit Kumar Chaurasia. Congress is already passed the any deliberately not comply.
Vikram Singh on behalf of the respondents. This foreign is granted. How much time do you want? 4 weeks time to comply with the cost part. File the compliance report. List after 4 weeks.
Final.
Take it with. We'll take up, there are 4 or 5 more motions, we'll take up that and then come to your case.
The registration was required to be filed as files along with all the requisite documents.
Mm.
You have to put in the question of for any bulky record of appointment of over 11,000 candidates.
Mm.
So I'm very sorry to file that registration. In fact, I have just kind of copied by the petitioner as well.
Mm.
And we are required to, as you also had, on the last date that a common to be filed, but we got a copy from them, we are required to.
We are also doing it at our end. Just some more time. No, as far as tabular, as far as I'm concerned, Lord,
It should be sanctioned.
therefore, for that tabular that we are making. Because it will involve it now, the production done a lot of. Therefore, we wanted to be pitch perfect about it.
Can we dispose of all these cases and say that the judgment of the Supreme Court will be followed? That's all. You follow the Supreme Court judgment.
First,
We have not adjudicated anything. So you read it, understand it and implement it. If somebody has a problem, we'll come to the court.
My lord, first, my lord, will be done. ID number 528. We start the last date of hearing, no reply has come. In that, Lord, has said that K.C. Nandan, Lord, and Rohit Chaudhary, both of them, my lord, have got appointment. So as far as their petition is concerned, that can be dismissed as having become in practice. Because that is, because service matter PIL is not maintainable. And this is not a co-warrantor, nor is this the scope of co-warrantor. But co-warrantor is right after the appointment. My learned friends also know it very well. So Lord K.C. Nandan may be dismissed because I have not received reply to 5284. My lord was appreciating that argument of mine in the last case of hearing, I remember, that there are only 2 petitioners in K.C. Nandan Sahu, and both of them have got appointment. Nothing remains in this petition. This petition may kindly be dismissed.
Your Lords, I appear for the petitioners in Kesari Nandan. If your Lordships can just hear us for a minute. After the Supreme Court's order, which has been passed, which is dealing with the substance of, I'm sorry.
BED holder, BED not interveners in K.C. Nandan Sahu. So Lord, I was saying as far as K.C. Nandan Sahu is concerned, because PIL is not maintainable, Lord, in service matters. And this is not a case of co-warrantor, nor is the scope of co-warrantor like this, my lord and my learned friends are well aware. All of us are practicing on service matter side. So, in there, therefore, only thing is that K.C. Nandan will have to be dismissed, provided you file a reply to 528. No reply.
We'll deal with that later on.
Let that.
But there is a request made by the state that
Yes.
there is more time for filing that table. Now, the suggestion of the court to the state is that since there is no question of any adjudication, because that has been done by the Supreme Court. So we will
Yes.
say that the state should follow the Supreme Court judgment.
But
That's
I am
fine.
for the selected candidates, my lord. We are all right with that. Let the state take a call. And because according to us, we are covered by that order completely.
Lords, that will have another round of litigation then, clearly from the positioning that is being taken. Because I can show to my lords that my lords have passed at least 3 interim orders saying that all appointments will be subject to the outcome of the final in the writ petition. Now, the Supreme Court's order, which has been passed,
Is it doubtful?
I beg your pardon, my lords, I couldn't hear.
Either you say it's ambiguous,
no,
it's
we have
not clear.
My lord, is absolutely crystal clear. It's only if the person who is appointed had filed a petition and got an interim order
That is
he
not said.
will not be. He will not.
I
be
think
protected.
Mr. Patwale has
Otherwise, he will be
misunderstood
clearly
the order.
protected, my lord.
Completely.
That's
That
the whole
is-
intention
Simplest
of the
thing is
order.
to read the order, my lords.
Yes.
There are
My lords,
only 2 conditions that are required. The first condition is that the person should have been appointed, a BEd candidate should have been appointed prior to the date of the Supreme Court's judgment. The second condition, if that BEd candidate wants to continue to have the protection, that BEd candidate should not have had his appointment made subject to any order of a court. In our case, as far as Madhya Pradesh is concerned, after the advertisements came, challenges were brought before this court, including in Kesri Nandan's case. Your lordships passed not one but two interim orders. The minute those interim orders were passed, the guillotine has fallen on all BEd candidates who wanted to take advantage of the NCTE notification.
That's a
That's all the
misreading of the order.
interpretation is.
The order
So
is very clear.
if we can
It
show your
says would be
lordships
subject
the
to final
order. We have
outcome.
filed a
It
compilation.
might have been
Mr.
instituted by
Patwale
then.
is for an intervener. I'm sorry. Can you allow me to complete? I'm the petitioner in the first lead matter. We have others have also intervened. Let me just argue on behalf of the petitioner. We have filed a small compilation, my lords, to put everything in one place to make it clear and simple. If your lordships can just take that.
Is it the court?
We have to take it back to the department.
Yes, we have placed it before the court.
There are 1,000 people, maybe 10,000 people. So how many will come back? Not more than 5%.
Because we don't miss.
Absolutely right, Munot. Let the
That's
state take a
11,000.
call as to what is
It
to
will
be
get
done.
opened up all over
affidavit.
again. The
1
idea behind
minute,
the
Mr.
Supreme Court reviewing its own judgment and giving a final judgment was to ensure that nothing more will trickle up, my lords. I'm just suggesting your lordship may see your orders and the advertisements. That will put everything in the clear.
My lords, as per the state government in its affidavit filed before the Supreme Court, the dates of appointment are crystal clear. Those dates happen after the orders passed by my lords, including there was an impleadment filed by these candidates before the Supreme Court, and Supreme Court had itself in an order said that the all appointments or whatever in the pending proceedings will be subject to the outcome. So not only was this court, but there was also the Honorable Supreme Court's interim order there.
Can we just show you the Supreme Court's order, my lords? It's April. That's the only thing of which an interpretation is sought now.
Kesri Nandan and Rohit Chaudhary.
No,
So
we-
that petition should go, but why they are opposing, I fail to understand.
So, Rupra, we are dealing with the real issue. Your issue is not so real as the issue of, let us say and let us take out the Supreme Court judgment and take out points, because we were hoping and expecting the state to assist us. But the state seems to be,
Therefore, we opened by submitting that on 15th of
because there is no adjournment, no adjudication left now. There's no
The state has to come out with a stand as to what they are doing, and ultimately whoever is aggrieved can have redress against that.
Parties are directed to find a common ground.
Well, if you take up the compilation which we have filed on behalf of the petitioner,
And therefore, that
only to assist the court. Now if the court does not need your assistance, you prevent the court from going ahead.
I'm only teaching this honorable court.
Because the entire adjudication has been done by the Supreme Court.
Absolutely right.
Do that.
Absolutely.
We don't have to indulge into that.
It's almost ready. We have received from my
well, there's no reason for the state to continue delaying like this.
That's fine. We'll deal with that as per we'll say that state government should implement the Supreme Court judgment.
But can we just draw one interpretation, because rather than open it up in future,
Make that clear. That is why I am repeatedly emphasizing my idea 5 to 8. Supreme Court judgment deserves to be implemented.
My lords, may I make a submission here, if my lords may permit me?
Deserves to be implemented
My lords.
in respect of Vipin Kumar Dwivedi and all those advocates, my lord, who are representing the petitioner in Kesri Nandan have no right to address this court because nothing remains in their case.
So let us take up the Supreme Court.
Yes.
Let us take.
it's at page 20 of our compilation, Manoj. In Kesri Nandan, in the lead matter, we have filed a compilation
No,
at page 20 of which
let them demonstrate.
is order of 8th April 2024.
Mr. Rupra, we'll take up your case later. First, we'll take up the main issue.
The main issue, my lord, is in Vipin Kumar Dwivedi. Kesri Nandan cannot.
Where is that Supreme Court judgment? Where is that?
It's a Page
Vipin Kumar,
20 of
Manoj,
our
it is there.
compilation.
That is the main judgment. KC Nandan is some PIL, which is not even maintainable, my lord.
Manoj, we have filed a
think-
compilation in the lead matter in item 24, in which at page 20 is the order. It's order with April 2024.
In the first week of May, let it be heard finally, commencing from 1st of May.
We had sought your assistance. The court does not need your assistance, and our adjudication process is over by the Supreme Court. Now it is only that we have to just point out that what has to be done. That's how it is to be implemented. That is all.
Exactly, Manoj. That's all that needs to be done.
It will be general. It will be a generic kind of an order direction that if this happens, please do this. If this happens, please do this. If this is the eventuality, do this. Otherwise,
That's right, Manoj.
it is covered by the Supreme Court. Who goes out and who remains in service and who gets out. That is all to be identified. That's all.
It's an important issue.
Yes, sir.
There is a writ petition in the BUG. The petitioners are appointed already. How can they maintain the writ petition? There are so many issues which have to be addressed before the Honorable High Court.
That we'll deal separately. We'll deal separately that Mr. Rupra's objection. We'll deal that separately.
So therefore,
Would your lordships have the court's order, Supreme Court's order?
we have already almost prepared it. I don't know why my friends are objecting to it. This matter is posted the first week of May. Let it be heard on any day, recommencing from 1st of May.
My lords, if we may see the history of this matter and the number of times the state has asked for an adjournment, on the contrary, in the last proceedings, my lords, this comment that the state is deliberately taking a position which it should not be.
Because she is in KC Nandan. But please first beat out these cases, Lord. One is KC Nandan.
Let's not get into locus standi now. There's a Supreme Court order at your behest.
A PIL has to be rejected at the outset, my lord.
The
The
state
PIL
of
can't
Madhya
be
Pradesh has
maintained.
gone to the Supreme Court and got an order. That order has to be implemented. Can we just see that order now?
Either you say that PIL is maintainable, service matter, show me some Supreme Court ruling. So,
May I say this, my lords, let's put a quietus to this. There is Kesari Nandan and there is Vipin Kumar Dwivedi. There are two matters before my lords and they both are available for my lords for
I
consideration.
don't know why my friend keeps saying it's a public interest litigation. If he at least reads the papers of that writ petition, you will see it is a writ petition on behalf of DL-led candidates. I don't know why it suddenly become a public interest litigation.
because
This is obviously just a scheme to try and interrupt us when we are placing the order before the court.
It says, I read that the instant petition was filed challenging these notifications, whereby candidates possessing BEd were made eligible for post of primary school teachers. Petitioners also participated in the same process, holding the degree of DL-Ed.
Precisely why it's not a public interest litigation.
For the post of primary school teachers in the same selection process, which they are challenging. The name of petitioner number
So it became a
1
public interest.
dated 4/4/2023 of District Anupur at serial number 225, that is filed here as an action IA1. The name of petitioner number 2, Rohit Chaudhary, is mentioned at serial number 25 of select list dated 4/4/23, 4/4 IA number 2. Both the petitioners have joined on the basis of the said orders dated 4/4/23, IA1 and IA2, and are working in District Anupur and District Dhar respectively as primary school teachers since last about 1 year. Their employee ID has also been created.
My lords, may I make a submission to cut this short? There are two matters before my lords. Vipin Kumar Dwivedi and Kesari Nandan, my lords may hear us and then hear them later on that.
No, but
this-
they have no right to address the court.
I can't understand. That's for my lords to decide later on after we have put up a case.
Or the BA candidates go out of the court or not? How Lord Kesari Nandan or Rohit Chaudhary is going to be affected? That is the good question.
In fact,
Kesari Nandan can argue. Vipin Kumar Dwivedi are prepared to argue right now, but no counsel should buttress the case of Kesari Nandan and Rohit Chaudhary.
I will. I fully insist that I will.
First, kindly address on locus. Who are you?
Because Mr. Luthra should clarify whom is he appearing for. His intervention till date is not been allowed. Who is he? He's not a respondent in my matter. How can an intervener whose intervention is not allowed have the first audience at all?
It's allowed, intervention is allowed. That was allowed long back. And right from the beginning, we have been insisting that this Kesri Nandan has been rendered infructuous because both the petitioners, they already have been appointed. And having participated in the same process of
Alright, we are resolving the cases and we'll try to decide the cases. If it's difficult for us, then we'll release.
My lords, as the petitioner in the first matter, can I have 2 minutes?
If certain facts are evident from the pleadings, I think it should be evident from pleadings.
My lords,
That's
and
good.
in that Vipin Kumar Dwivedi, can I point out three
Can we
orders?
make just 2 minutes of submissions on behalf of the petitioner? Just 2 minutes, that's all. It will not take more than 120 seconds. Yes, my lord. It's simply this. If you look at the order of the Supreme Court, there are very clearly, it states, your lordships have seen the order, then I'm not going to trouble your lordships with it. But I'm just reading out 2 sentences from it, which is the relevant portion of it. It says that before us, 2 sets of parties are there. One set wants retention of the said judgment in its present form. The opposing side alleges that it would result in loss of employment to those who were already appointed as teachers in different states on the strength of their BEd degree. This BEd qualification was what was struck down by the Supreme Court. It is submitted that they had entered their employment following a legitimate course as per notification issued by respective appointing authorities, which did not stipulate.
Where are you reading in the order?
This is in the Supreme Court's order, page 5 of the Supreme Court's order, my lords.
Okay.
It's page 24 of the compilation, if you have the compilation.
Yes.
It's at page 4. It's the bottom paragraph at page 4.
Yes.
So it makes it clear who the 2 sets are, my lords. One who wants retention, the other who are those who have been appointed as with BEd qualification who don't want to be thrown out. That's the 2 sets. Now, after having considered all of this, if your lordships will come to the bottom of page 7, which is 26 of the compilation, bottom of page 7.
Yes.
As it appears that a large number of candidates with BEd degree had already been appointed on the basis of eligibility criteria specified by the educational authorities, we do not think it be equitable to effect their removal. We accordingly hold that the judgment delivered by this bench on 11th August 23 shall have prospective operation. But, and this is what we are relying on, prospective operation of this judgment shall be only for those candidates who were appointed without any qualification or conditions imposed by any court of law to the effect that their appointment would be subject to final outcome of the case, which might have had been instituted by them, and such candidates were in regular employment without any disqualification and were appointed in pursuance of a notice of advertisement. This is the second condition. Appointed pursuant to notice of advertisement where BEd was stipulated to be valid qualification. Yes. Services of only such candidates shall not be disturbed because of this judgment. We make it clear that this benefit is only for the candidates who were appointed. Please note, appointed prior to the date our judgment was delivered, that is on 11th August 2023. Mere selection of such candidates or their participation in the process will not entitle them for a benefit under our present order. I'll just give your lordships the relevant dates, my lords. The first advertisement that was issued was on 6th January 2020, after which we filed our writ petitions, my lords, in which, and this is why the locus point keeps coming up, we asked for not only the striking down of the NCTE notification, but also that BEd candidates not be made eligible. Even in the future, if they are allowed to take part, it would affect us. The High Court passed interim orders dated. Please note these dates, Malo. This is relevant because both these dates are before the Supreme Court's order. 7th July 22, your lordships passed an interim order. 7/7/22.
My learned friend is not here. Here, I expect to never want to.
Pursuant to which some of these people went and intervened in the Supreme Court.
It does not survive, Lord. Why my learned friend is not addressing on locus, Lord?
After 7th July 22.
After he finishes,
surely
I
I
want to
can
respond to
complete
what
what
is
I'm
being
saying, my lords. Surely I can complete what I'm saying.
Now,
The
whether
first
it-
interim order is 7th July 22.
that is
The
not-
second interim order is 16th January 23.
Kindly appreciate, Madam. Yes.
7th July 22 and 16th January 2023. The order of the Supreme Court, the judgment of the Supreme Court, which is the cutoff date, is 11th August 2023.
Very first
Now,
occasion, Madam.
of our friends who have been appointed, I'm sorry,
Learned Friend is taking your ownership to the judgment of the Honorable Supreme Court. Now, we are not quarreling on the issue that some judgment is pronounced by the Honorable Supreme Court, and it has to be implemented. There is no quarrel on this issue. But then the point
Can I
is,
just-
maintain
can I
the how to address the Honorable
Lord,
Court on this issue.
may I respond on the judgment of the Supreme Court?
I'm just completing, my lords. I'll just take half a minute to complete now.
He's arguing in which case?
My lords,
I'll just take half a minute to complete, my lords. We had the same problem in the Supreme Court because people who are anxious to protect their jobs are obviously very anxious. I can understand that. I'm just stating the facts now.
Your clients, Mr. Shankar Narayan,
Yes, my lords.
are diploma holders.
yes, my
Yes,
lords,
we are
both are
DLED
clients.
holders. We are the only ones eligible for these
They have
posts.
been appointed. They have been appointed.
They've now been appointed. Now, yes.
All right, so,
No.
so they will not be adversely affected by this Supreme Court judgment.
The BEd candidates who are senior to me, they are the ones who are going to affect me. All of them have to be out. If they, as per the Supreme Court's order, if they did not have the protection of an interim order,
Yes.
then it's a different matter. Here there was interim orders which protected us, all of us as petitioners, and said that it would be subject to outcome. And those interim orders were passed prior to the cutoff date, which is 11th August 23. Two interim orders were passed. And my lords, the Supreme Court has said you must look at the dates of appointment.
That is evident from the record.
If I may now, if my friends 2 minutes are
Yes,
over, if I
we're
may.
just drawing your lordship's attention to two
Before-
facts. One, the dates of the interim orders.
This is what they did in the
Two,
Supreme
the
Court.
dates
They didn't
of
allow the other
actual
side to argue.
appointment.
We
The
go
dates of
through
actual
that, we go through the record, Mr. Shankar.
Lord, may I just have
Very
2
well,
minutes?
then I won't
May I
say
just
anything
have 2
further.
minutes
My
from
lords,
the
can
other
I,
side?
before
Lord?
Mr.
Now,
Patwalia starts,
before the
I'm for the
Supreme, just 1
petitioner.
minute, 1 minute.
Mr. Patwalia,
You
I'm
are
for
both
the
on the same side.
petitioner.
Please let me present the other picture.
My lords, can I appear for the petitioner and then Mr. Patwalia can argue?
Lord, they are both on the same side. So
My
let
lords,
me
that's not
present
the
the other
case. I
picture now
appear
that
in
one side
another
has been
matter and I
presented.
want to point different facts. Please do not do that, Mr. Patwalia. I appear in a different matter with different
This is
facts.
what happens.
You
Anyway, I'll
did
wait,
the
Lord.
same thing in the Supreme Court, not
I'll
allowing
wait.
anyone to argue. Please,
I'll
don't
wait.
repeat it now.
Yes.
My lords, I'm going to be very short and crisp. I won't take longer than at
Now
least a couple of minutes. Now, my lords, can I just say one thing? The crux of the matter is the Supreme Court says the appointment had to be without any disqualification. The submission that we make before my lords is that in the writ petitions that were filed way before.
Lord, I have to make a point. Lord, I have to make a point. I'm on the other side. My point is this, Lord.
My lords,
If
there are
it is
4
infraction.
interim orders. There are 4 interim
Lord,
orders.
let me make my point. Lord, that's what they want, that they should argue, other side should not argue, matter should be reserved. Now, the other side is, before the Supreme Court, there were two kinds of BEd candidates. One BEd candidate was where the candidate himself had gone to the Supreme Court because the state had declared him ineligible. Now, the other were where the state was declaring them eligible under the notification.
Find BEd candidates. No, we have not filed any petition by them. That is the
Yes,
order.
yes, I agree with my learned friend. Just kindly read one line of the Supreme Court order, my lord, which appears at internal page 8 of the Supreme Court order. Can your lordship take the bottom of the Supreme Court order from page 7? Just kindly have page 7 at the bottom. I'll read that paragraph. As it appears, your lordship has got that, my lord, as it appears.
Yes.
As it appears that a large number of candidates with BEd degrees had already been appointed on the basis of eligibility criteria specified by the educational authorities, we do not think it would be equitable to effect their removal. We accordingly hold that the judgment delivered by this bench shall have prospective operation, but prospective operation of this judgment shall only be for those candidates who were appointed without any qualification or condition imposed by any court of law to the effect that their appointment would be subject to final outcome of the case which might have been instituted by them. Why? Because Rajasthan had declared BEd ineligible. In Rajasthan, the BEd candidate had gone to the court and wanted to appear. The BEd candidate appeared provisionally under orders of the court, even though he was not eligible as per the Rajasthan advertisement. Then he lost, and therefore he is ineligible. A similar position happened in Chhattisgarh. Chhattisgarh decided against the BEd candidate. There, the BEd candidate went to the Supreme Court and he appeared subject to result of the Supreme Court. So it is only where a BEd candidate had instituted a litigation and appeared on the basis of that interim order that he is not to get the benefit. Here are cases where we are people who are eligible under the state rule. The rule still holds valid up to today. We have been appointed.
Sorry, this is
Our
completely
appointment order
preposterous.
does not contain any condition that it is subject to anything. We have an absolute appointment letter in our favor. And the Supreme Court therefore says only if the BEd candidate has got some interim order and got appointment on the strength of that interim order, only then he is not to get the benefit of the judgment.
So,
That
my
is the
lords,
real
now may
import.
I respond
There
to
are-
this?
Just
Now
one
may
minute.
I respond to
There
this?
are, my lord, there are
My
three
lords.
parts of the, just 1 minute, Meenakshi. There are three parts. If your lordship will see page 5, the para in the lower half of the page, there are three places where the Supreme Court says, if you are appointed, we will protect you. That is the underlying order. If your lordship will see para 5, bottom of the page, before us, two sets of parties are there. One set wants retention of the judgment in its present form. The opposing side alleges it would result in loss of employment to those who are already appointed
That
as
will
teachers in different states
My lords, may I
on the strength
respond?
of the BEd degree.
Get that.
Then again, my lord, 6 at the top, see what the court says, page 6 at the top. Now, having considered these factors, particularly the contention of BEd applicants that they have entered into employment as per the qualifying criteria specified by the appointing authority, equity should go in their favor. This line is very crucial when we read it with page 7. Those candidates who have been appointed because they were qualified as per the criteria of the appointing authority have all been protected. It is only those candidates who were not qualified as per the state criteria and who secured interim
That is
orders.
also, Mr. Patwalia, I hope I'm pronouncing your name correctly.
Yes, absolutely, my lord. Absolutely, I'm grateful.
That is also subject to certain conditions mentioned at page 7.
Correct. So
Yes.
let us read it, my lord, because it was hotly contested.
We'll clarify that 1, 2, 3, 4. If this happens, retain them. If this happens, don't retain.
Yes, because then your lordship will have to read the first 4 lines of page 8 very carefully, because any court of law that their appointment would be subject to final outcome of the case, which might have been instituted by them.
Manoj, in this
If the other
case,
side's interpretation is
candidates from
accepted,
BCA
and
filed
nobody
an
is saved.
application in the Supreme
No,
Court.
this is not the object
Mr.
of the
Patwalia
order.
is not disclosing that.
The
On
object
11th of
of
October 2022,
just please don't
the
talk over me.
candidates from
You will
MCA
have
filed an
time.
application in the
Allow me to
Supreme
finish.
Court.
Allow me to finish. Don't get anxious.
So at least take the right
Now
facts.
the point is,
Mr. Patwalia, please finish.
yes. So, my lord, I am only saying, my lord, the underlying object of this order at 4 places is anybody who has secured appointment should be protected if he is qualified as per the state government regulation. It is only if you have secured an appointment when you are not qualified as per the state government's rules by securing an interim order that you are not protected, is my respectful submission.
My lords, may I
And
just
my
have
second
by the
respectful
clock?
submission is,
By the
if
clock,
this
my
interpretation
lords.
is not the correct one, then this order protects nobody. Then everybody goes, because everybody who is there was all subject to some writ or the other, and therefore this order
Yes, my
becomes
lords, let us now
completely odious.
let us look at what has transpired here. 1 minute now,
my
Mr.
lord, also
Patwalia. I think
Calcutta High Court, in fact, has also passed an order.
Mr. Patwalia, let Ms. Arora also.
my lords,
make
just
One
few
last
minutes,
line,
and
one
I'll be
last
very,
line.
very quick
The
with this.
Calcutta High Court has passed an order on 19th, and the Calcutta High Court has said exactly what your lordship said when the hearing opened, that Supreme Court has decided the state government is to take action strictly as per the Supreme Court order.
Please give us the
So,
copy.
my lords,
Mr. Siddharth Shukla will have the order, my lord. Mr. Shukla can pass on to your lordship, my
so,
lord, that order.
so my lords, now where the state is
If your
making a
lordship, just one
submission
line,
and
one
Mr.
line.
Patwalia is saying that, I think there is a need on how my lords will pass this order. May I just show very, very quickly few pages which I say is completely the Supreme Court order when it cannot be applied in respect of BEd candidates who have been appointed when my Lord's direction to the state were already in place that appointments, if any made, will be subject to the final outcome. The first order that my Lords passed was on 7th of July 2022. My Lords, the date is very important. My Lords will find this at page number 1 and 2 of my Lord's compilation, to which Mr. Gopal Shankar Narayan was referring to. My Lords, on 7th July 2022, on this date, no appointments had been made, but if any appointment, I take it, had been made, will be protected by Supreme Court order, but after this, definitely not. My Lords, after this court passed an order on 7 July 2022, and the relevant part is recruitments in question and any appointment made shall remain subject to final outcome of this petition. My Lords will find it at page number 2 of this particular compilation. Now, my Lords, what happens is that on 11th October 2022, BEd candidates file an application before the Supreme Court for intervention. The matter comes up on 12th October 2022. Yes, for impleadment. And my Lords, the matter comes up on 12th October 2022. The office report notes that this application was before the Supreme Court on that date. Please turn to page number 7 of this compilation and please see the order passed by the Supreme Court on 12th October 2022. And it says, my Lords, any steps taken during the pendency of these proceedings having impact on the controversy out of which these proceedings arise shall be subject to the final outcome or any further order that may be passed in this matter. Now, BEd candidates have approached through an impleadment, and this is an order that is passed by the Honorable Supreme Court. Now, my Lords, the first advertisement thereafter of the state comes on 19th October and 16th of November. And my Lords, another advertisement comes up on 26th of November. The writ petition is filed before the Madhya Pradesh High Court, and Madhya Pradesh High Court by an order of 16th January 2023. All these orders are prior to these appointments. My Lords, please turn to page number 8 of the convenience. Now, please turn to page number 8. This is not now Keshri Nandan, this is in Vipin Kumar Dwivedi. In this petition, the court says, all further actions by respondents will be subject to further orders of this court. My Lords, the way Madhya Pradesh government has been going, my Lords should see, because there's a direction to them and they are aware that they can't make these appointments. Now, my Lords, what happens is that the appointments for the first advertisement, which is 19th October 22 and 16 November 2022, happened between 30th of March 2023, which is after my Lord's order of 16 January 2023, to between 15th of April 2023. Would my Lords be so kind and turn to the affidavit filed by the state of Madhya Pradesh before the Supreme Court? My Lords will find this affidavit at page number 12, and the categorical statement made by state of MP is at page number 16.
All this has to be now going by the final order.
1 minute now, Mr. Patwalia, you've had your say.
It has to follow all appointments
Yes,
which have been made
now, can
on petitions
we,
not filed by
Mr.
us.
Patwalia,
Will have to be
please
saved.
don't obfuscate the other side from presenting their case. You have said, please allow me now. Now, my Lords, this is an affidavit filed by state of MP. Please come to page number 16. And this is very, very important. It says, my Lords, in the second paragraph, first of all, there were a total of 21,962 appointments, out of which 11,583 were given to the BEd. Now, what are the dates on which they have been given? Please look at the tabular chart below. 30th of March 2023, a total of 16,000, out of which 8,799 were BEd. 10th of August, my Lords, 1 day before the judgment. 1 day before the judgment, and I say this, my Lords, this is very unusual.
Who would know
Let me call it unusual.
This
Yes.
is just
Lords,
creating
we
doubts
all
for
know.
nothing.
Mr. Patwalia, you've had your say. Please now rein your horses. Now, my Lords, on 10th of August 2023, 5,617 appointments, out of which 2,784 to BEd. Now, all these appointments are post orders of my Lords of 7th July 2022 and 16 January 2023, including the Supreme Court order of 12th of October 2022. My lords, I submit with complete humility when the court at page number 7 of its order, the Supreme Court, which my lord saw just now, at page number 27, bottom of page 26, 27, please read it now in that perspective. What has happened here? Once these orders had been passed, these appointments were all subject to the outcome. Today, the outcome is clear. The Honorable Supreme Court has held BEd is not an eligible qualification for the purpose of appointment to the post of primary teacher. The eligible qualification is DLED. The only thing the court has said that if you had been appointed without any restriction or disqualification by any order of any court, my lords, that's page number 27. My lords just saw that. Only then you may be protected. Here, clearly, there was an order of my lords which put a disqualification that these appointments will be subject to the outcome of these petitions. My lords, the second thing that I most humbly submit to you is this. My lords, so far as the DLED are concerned, for them, the only appointments can be for the primary school. So far as the BEd is concerned, the scope is much wider. And that is what has been noticed also by the court in Divesh Sharma. Now, if we are entitled to only these limited vacancies and have no other opportunities, while BEd have still a much larger area open to them for appointments, there is no reason why, my lords, those of us who are eligible, qualified, should not be given these appointments. And I most humbly submit that today, in view of the Divesh Sharma judgment of my lords 11th August 2023, and including this clarification, the present appointments which as per state have been made on 30th of March 2023 and 10th of August 2023 are in teeth of that particular order of the Honorable Supreme Court. And my lords orders, the two orders that I've shown, 7 July, 16 January 2023, 7 July 2022, and Supreme Court interim order of 12th October 2023. My lords,
I can respond. It is, again, they have glossed over the words at page 8. They have been glossing over those words. Those words are crucial, that their appointment will be subject to final outcome of the case which might have been instituted by them. Supreme Court is crystal clear in saying so.
This is hair splitting, my lords.
Otherwise, Lord, nothing will be saved. Otherwise, this clarification is meaningless.
Mr. Patwalia, I think we have heard you.
All right, grateful. I'm sorry.
Otherwise, this process is going to become unending.
I'm sorry.
If every lawyer is going to respond to every sentence.
I'm sorry.
So,
well, on facts, can I just take 10 seconds? Just 10 seconds only on facts, not more than 10 seconds.
He's assisting her first.
Just 1 second, sir. The Honorable Uttarakhand High Court has followed the same retrospective application, and the Supreme Court dismissed the SLP, saying that whoever has been appointed post the interim order has to be out. Recently, the Honorable Supreme Court on 5th April 2024 has dismissed the SLP filed by the BEd candidates. That's number 1. Where the Uttarakhand
that was before said, the clarification.
1 second,
please
sir.
tell them
Sir,
that is before the clarification.
If you don't mind, sir, please, if you don't mind, please. The Honorable Uttarakhand High Court has followed retrospective application wherein interim order, any appointment post that, out. Number 2, my lords, the Honorable Chhattisgarh High Court has again followed the same principle of law, where they say that any appointment post an interim order will not succeed in case they have been appointed post that interim order. So, my lords, when multiple high courts have been following, and if my lords would want, we'll put that in a written submissions, not more than 5 pages, we'll put all of that, and how all the high courts across the country have thrown all the BEd candidates out where they have been appointed subject to an interim order passed by the Honorable respective High Court. That's all.
In those cases, I am told applications are being filed for recall because of this clarification. Those are all prior to clarification.
Today, there is no recall.
I hope the council appearing virtually have concluded.
Yes, yes.
We are grateful, Mr.
We are extremely grateful. Very kind.
We will get a chance. We are very sure. After these, all these people on the verbal hearing, and also like to address because of them have not. Let them address, Lord, we are silent. After that, my learned advocate general is also there. After that, हम लोग को चांस देंगे.
Yes. Yes.
Lord, please see. Admittedly, the advertisement was issued once. The first advertisement which was issued.
I think the learned advocate general has the right to first audience. First audience. Yes.
Definitely.
Firstly, your lordship can kindly see, there are uh, 5 writ petitions in which it is said whether the interim order was passed. So, your lordship can kindly see WP number 13768 of 2020.
There was an interim order, yes,
The interim order was passed on 7th of July 2020.
yes.
Now we are raising serious objection with regard to maintainability of this writ petition because the petitioner hearing have already been selected and appointed. Now, this writ petition has rendered infructuous. Now the second writ petition is WP 595 of 2023.
Yes.
In this matter, my lord, the judgment from Honorable Supreme Court came on 11th of August 2023.
No, there was IR in this case.
IR was passed on 28th of August 2023. Subsequent to the order passed by the Honorable Supreme Court.
IR is dated is.
My lord, kindly WP 595 of 2023 within Kumar Vedi.
28/8/23.
Yes, and the order of the Honorable Supreme Court is dated 11th of August 2020.
Yes.
So here, while the appointments are not going to be disturbed in this writ petition, the another writ petition is WP number 21800 of 2020. Now, in this matter, interim order was passed on 14th of September 2023.
Yes.
Similarly, in WP number 2218 of 2023, the interim order passed by your lordship on 21st of September 2023.
Yes.
And then finally, in WP number 29809 of 2023, Vivek Pandey. Now, in this matter, the interim order was passed on 15th of December 2020.
December 23.
Yes, yes.
Hmm.
No, my respectful submission is,
Yes.
in the light of the judgment pronounced by Honorable Supreme Court and the condition imposed therein, the appointee in WP number 595, WP number 21800, WP number 2218, and 29809, they are not going to be disturbed. There is no appointment order will be disturbed, my lord, if we implement the directions of the Honorable Supreme Court, because it has been given prospective operation, my lord, and prior to passing of the judgment by the Honorable Supreme Court, there was no interim order passed by your lordship, my lord. Now there is only one writ petition which is left. Is Kesari Nandan Sahu's matter now. And in that writ petition,
Yes.
the appointment has already been granted to the petitioner.
Yes.
So they came before your lordship. Then they could not take up the selection process. They have raised grievance with regard to the selection process undertaken by the candidates and the initiated by the state government. And subsequently, these petitioners, they are appointed. Now we are, my learned friend Mr. Rupa and my learned friend Mr. Gindia, all they are raising, interveners are raising objections that they cannot maintain their petition. Now the issue to be taken into consideration before your lordship is, once the writ petition goes on this objection that it is not maintainable, but the interim order which was passed on 7th of July 2022 in that writ petition would also pass in the final order. Therefore, my lord, we have raised this objection, and that objection needs to be addressed. Now, while learned friends who are appearing in that matter, instead of addressing your lordship and assisting your lordship on this material issue, they are taking your lordship to the judgment pronounced by the Honorable Supreme Court. So, even we are saying the judgment which is passed by the Honorable Supreme Court that has to be implemented. Yes,
And what about the remaining cases?
So in the remaining matters, there are in most of the cases, notices are also not even issued. And no interim order is there.
That is 24.5 to 24.10.
Sir, कुछ में in few matters, notices are not. No, in fact, the notices are also not issued in these matters. 5-6 repetitions. What I am respectfully submitting your lordship, I kindly appreciate. The interim order which was passed.
So in 24.5, there is no interim.
Right,
Then
check it from
24. Now let us see 24.6.
Your lordship, I kindly appreciate. But I have referred the number of writ petitions. There are only 5 writ petitions in which the interim order was passed by your lordship. Out of which there are 4 writ petitions in which interim order was passed subsequent to the pronouncement of judgment by the Supreme Court.
Yes.
Now, in one of the matters, Kesri Nandan Sahu, in that particular, the interim order was passed on 7th of July 2022. That is much before the judgment date of pronouncement of judgment by the Supreme Court. And in that matter, we have raised this objection that writ petition is not maintainable. The petitioners are appointed. They have no grievance. And they maintain their writ petition before your lordship. Therefore, one of these need to address how this material issue was. How they have submitted that there are several appointees who are having qualification of BEd. Whether it is speeded in the petition, whether they have raised any grievance with respect to this category of candidates who have taken up the selection process and ultimately appointed by the state. So all these things are required to be seen, and therefore, but the objection which we have made to go to the roots of the matter, they cannot maintain that writ petition, and therefore, I am making a more humble submission that this objection which we have raised, my many friends have raised, they are required to address and assist your lordship on this issue. And once your lordship is satisfied, yes, then their writ petition, then whatever direction which your lordship will pass, will bow down to it.
That is the first place.
My lords, maybe respond.
First
Only in the case of incurring under South.
No, my lords, also in the case of Vipin Kumar Dwivedi, order was passed on 16th of January 2023. The prayers made in all these petitions are broad and wide, in fact, asking that BEd are not qualified at all. And my lord said that appointments, if any, will be subject to further orders of this court. It is at page number 8 of that compilation. That is 16th January 2023. The prayers are wide and they are across board, my lords. So it can't be said that it applies only to the petitioners therein and not to other people who will be affected by it. I don't think that may be a right submission at all to make in matters of this nature, where there is a challenge to that very policy, the qualification itself, which has been struck down. And we cannot lose sight of the fact that by this time Rajasthan High Court had actually struck down that qualification of BEd. The judgment of Rajasthan High Court pronouncing it in rem was already there. And be that as it may, nevertheless, if the state of Madhya Pradesh took a position, appointed people, cognizant of the fact that BEd is not a qualification struck down by Rajasthan High Court, Supreme Court says it is subject to the outcome of the proceedings. This honorable court, again on 16 January 2023, well before the appointments that took place on 30th of March 2023, said all further actions by respondents will be subject to further orders of this court. So those appointments are all with qualification.
Let us hear the counsel for the petitioner and Kesri Nandan. Yes, please.
That is Mr. Gopal Shankar Narayan was appearing.
Well, I'll assist Mr. Shankaran is just joining. I'll also have that compilation that we have submitted. We have produced the prayers in the Kesri Nandan matter, which may be relevant to address on the fact that whether the petition is maintainable or not maintainable. Allows me kindly have that compilation for a minute.
Mr. Kalra, Mr. Chaudhary is here to represent Kesari Nandan Sahu and another. Let him argue first. Yes. Huh?
The arguments of the Mr. Shankar.
Shankar Narayanan is not there on
He's
screen.
just joining in 2 minutes, my lords. If my lords would permit, I will assist till the time he joins. In case
How is
it comes South's matter.
Who is the petition now maintained?
I have challenged the legality validity of the MP Note 2018 as well as the notification issued by the NCT, including the advertisement issued by the DAPA.
Just take out your petition. Yes.
Fellows, for the ease of this court, the Kesari Nandan Sahu prayers are already there in that convenience. If that is what my lords are looking, that's only to assist my lords. And my colleague is here already anyway.
What is your prayer?
Yes, my
My
lord.
apologies. I had to
My
change
lords, the
systems
prayers
of
in
network.
Kesari Nandan Sahu, my lords will find at page number 2 of that small compilation itself, where the petition and the prayers are set out in second column.
Mr. Arora, let Mr. Thakur address.
Yes, yes, absolutely. Let Mr. Shankar Narayan take over. We were only assisting, my lords, in the interaction.
My lords, if you can just see the prayer in our writ petition. We have set it out in our compilation also at page 2. Do my lords have that? Do your lords have the compilation we had submitted?
Prayer clause in front of me. Yes.
Provide the compilation.
No, I have the petition in front of me. Prayer clause is there in front of me.
Yeah, prayer clause. So if I can just read that. The first prayer concerns the NCT notification. Now that has been decided by the Supreme Court. Finally, they have struck down the notification which had provided for BEd to be a qualification. The second, and this notification was the one that provided for the BEd candidates to have the eligibility. The second prayer, that the Honorable Court may kindly be pleased to issue a writ not to treat BEd candidates as eligible for the post of so-and-so without passing NCT prescribed bridge course. If I may pause here for a minute. The minute they have treated BEd candidates, they have appointed BEd candidates, and those BEd candidates get a preference over me, I am affected even if I am appointed. The simple fact of my appointment doesn't take the wind out of my sails completely, as my friend is choosing to argue. I have an issue with ineligible candidates coming in who will at later stages make claims regarding any avenues of progression that I would have, which is why it's very much maintainable by me saying that you do not have a legal qualification to be here in the same cohort as me. That is my argument.
We are raising an issue which is not here before us, and the issue is of seniority among
I'm sorry. It's a question of eligibility, Manoj. It's a question of eligibility. I'm saying if the entirety of the NCT, I'm sorry, I shouldn't have interrupted. I'm sorry.
You are raising the issue of inter-se seniority between the DLED appointees and the BEd appointees whose appointment has now been saved by the Supreme Court. Now that issue was never there. So
it wasn't, and I'm not raising that. Let me just clarify what I am raising. I am raising the fact that there's no question of inter-se seniority if the other person doesn't exist. The other person who is a BEd candidate, the Supreme Court has made it very clear that since petitions were filed and interim orders were passed, which is the virtue of which you are allowed to continue, you will not have the protection. So the BEd candidates go out completely. My issue is with the BEd candidates remaining in the room. That's my problem. They cannot be eligible at all. And that is why I was here in the Supreme Court as well, arguing this very issue before the Supreme Court. There was no objection taken to my locus standi here. I'm very surprised that somebody is taking it now in the High Court.
Despite having a BEd,
yes,
who have been appointed and saved by the Supreme Court, the appointments are valid now. Subject
appoint-
subject to satisfying those conditions in the Supreme
Correct,
Court.
correct. So if they have not if A, they were not appointed prior to the judgment, appointed. On the 10th of August, in fact, the day before the Supreme Court judgment, the notifications have been issued by the Madhya Pradesh government intending to appoint them, but not actually appointing them. That's a very important distinction to be borne in mind. There are two swaths of appointments that have taken place in Madhya Pradesh. One on an earlier date, and the second the day before the judgment, which is a remarkable coincidence. I'm sorry, between 30th March and 15th April, there were appointments carried out. But then on 10th August, they claimed that there were some more notifications issued, but not appointments made. Appointments are all made after the judgment. So they would not be saved either. As far as the interim orders are concerned, the interim orders are applied across the board to everybody. As a result of which, no BEd candidate in Madhya Pradesh can make a claim.
All right.
Right. I may point out that when the first interim order was passed, your lordships took note of the Rajasthan High Court judgment, the judgment that was sustained by the Supreme Court on the main matter. That was taken note of. I may also tell you that after your first interim order, these very interveners came to the Supreme Court, filed an application for intervention as well in the main matter. And yet the judgment came. So it binds them all down. I'm grateful.
Yes, Mr. Kapil.
But the interim order dated to the 8th January 2023.
Yes. Bola.
16 January.
Five 995 is 15 January. Yes.
Also, the interim order, all the further action by the respondent will be subject to other law.
Yes.
Regarding the one set of petition, KC Nandan and
सर उसी एक मिनट ट्रांसफर बोला एक पेज का जो है ट्रांसफर ठाकुर साहब बता रहे हैं आपको इसमें सर उसको फिर क्लियर किया था 28/8 को भी देखना होगा इंटरव्यू ऑर्डर उसी में नहीं
बनता है उसको थोड़ा नहीं हुआ है
28/8 को फिर क्लैरिफाई किया कि अपॉइंटमेंट सब्जेक्ट टू आउटकम रहे इनिशियल में दैट वाज नॉट द डायरेक्शन
dealing in length without this order is also
repeated directions are not passed by the honorable court. It is only when by the initial order which was passed on 16th of January.
If you see the 16(1) order, it's of a very generic nature. It covers everything. Further action by the respondents will be subject. Further action means recruitment plus appointment.
Your lordship may kindly see the subsequent interim order on 28th of August 23 in the same writ petition.
Yes, yes.
Was the intent of the honorable court that the appointment shall be disturbed, but the subsequent interim order can be passed by the court. But then, my lord, specifically the court was kind enough to direct that no further appointment shall be made. And this, that the order was passed on 28th of August 2023.
Yes.
Now, the electorate cannot skip this order and refer the initial order in which this order the court never directed that the appointment order shall be kept subject to final order.
Yes.
So, my lord, both the interim orders are required to be seen.
Yes.
I'd be surprised, my lord, that my learned friend will say that repeated interim orders are required to be passed by the honorable court. My lord, I have not seen in my life, my lord, that repeated interim directions of similar same nature is passed. Once the interim protection is granted,
Yes.
end of the matter.
Yes.
It is there, but because there was no intention of the honorable court to keep the appointments subject to final outcome, and therefore subsequently on 28th of August 2023, my lord has specifically challenged. Now keep all the appointments subject to final outcome.
That we have noted. Yes.
Now,
Yes,
my lords, please. My lords,
Have you completed? No, please talk about Kesri Nandan only. Your counsel in all petitions. So what remains in Kesri Nandan now? The relief that you have sought has been granted. What other relief
This
you
is
have?
my relief, but I'm not given the appointment. And sir,
And what are you claiming?
relief.
Yes.
I have challenged only the validity of the rule of the state government published in July 28.
Which rule? Where is that? Where is that challenge in the prayer floor?
Para 7.5, Manoj, at page 30 is the challenge to the rule. Para 7.5, page 30.
Schedule 3, yeah, Madhya Pradesh School Education Conditions. With advertisement date 60/2022 contended and 51. Only to the extent of Madhya Pradesh primary teachers eligibility test 2023. Restraining the BEd degree holders candidate for appointment on the post of primary teacher, school teacher, and to give appointment only to those who are DLED diploma holders candidate.
This is already granted to you by the Supreme Court. Granted हो गया ना ये तो. They have said that DLED is the prescribed qualifications. And so far as BEd appointees are concerned, they have passed certain orders protecting some appointments, not protecting some, subject to certain conditions. Are we going to sit over the Supreme Court? Then Supreme Court has decided that case. Supreme Court has upheld the Rajasthan High Court order. Rajasthan High Court quashed the notifications. This order of the Supreme Court also covers the all other cases mentioned, I think, in the last paragraph.
All other states also. It covers all states.
It is clear that directions contained in the order shall not be confined to the applicant, state only, and shall cover all cases which may be pending in different judicial fora in any state or union territory on the same point of view. What remains now? Anything else? Who?
Only
No, there are only two petitioners there in this petition.
and other petitioner also
Which petition? In which case?
Point one, Will Kumar Dwivedi, they have not appointed. And Tarun Agarwal, there is, and petitioner, they are also not appointed.
So this Vipin Kumar Dwivedi, what diploma holder or
Diploma, only the
diploma holder?
Manish Sen is not, they are also not got appointment. The petitioner diploma about the unit.
There are two petitions. Same petition.
Yes.
Prayer are same or different? Same. Copy paste.
Lords, it will be fortunate if they are copy paste because then they are wide in nature and they are then in rem. So even one petition will cover the relief for everyone else who's similarly situated.
All the parties are directed to act in strict compliance of the law. It's a past notice of office. That will serve the purpose of the protection fund. If you have option, sometimes it's order.
That is exactly what I had said in the beginning.
Yes,
That-
yes, but there's something about that direction.
So let the state government,
Directions of.
let the state government implement. If there's any folly in the implementation
Yes.
process, they'll come back to it.
That's the, yes. Yes.
My lords, with that, I think it's a writing on the wall. If my lords have heard the argument of the learned AG, my lords, then it's a writing on the wall. My lords, the learned AG has in no uncertain terms suggested a particular position, and which I guess will be the position of the state. I would request my lords to my lords.
Also argue. Yes, yes, Mr. Devi.
Manoj, please see. Manoj, notice few things. So this advertisement is issued on 6/1/2020. Why I am drawing the attention of the lordship, I relate it to the order passed by the Supreme Court.
No, Mr. Gilia, you are appearing for?
Or I am appearing in K.C. Nandan as well as this Vipin Kumar, we earlier made filed intervention application. Our applications are allowed, and we are included as respondent.
You are BED appointees.
No, no, we are.
Yes.
Now, Manoj, kindly notice, the advertisement is issued on 6/1/2020.
Yes.
The examination is held on 5/3/2020. 5/3/2020.
After more than 2 years.
Yes.
This is written exam.
But this was delayed due to COVID and all of the certain examination.
All right.
Then, my lords, this petition was filed on 13/6/2022. K.C. Nandan's petition
15/6.
2022. And it was filed by these petitioners who had already participated in the process of selection. They went by the conditions of the advertisement, participated in the process, and thereafter they filed this petition on 13/6/2022. The interim order was passed on 7/7/2022.
Yes.
During pendency of the petition, both the petitioners got selected and appointed.
When was that?
Well, their appointment orders are fixed. Well,
The appointment orders.
both are appointed. Well, we had supplied the copies of their appointments. I'll just give the dates. 4/4/23.
Both. Same date.
Yes. They both were appointed.
Yes.
Now, can you see the relief clause words, which Manoj have just seen, relief clause in the report? Because it has been said that their grievance still subsists. Now, how it subsists, Manoj, is relief. 7.1 is Manoj that relief they have already got. As per Manoj, 7.1 is concerned. That NCT regulations Manoj, that has already been declared Manoj. Now, can we see 7.2? That the Honorable Court may kindly be pleased to issue an appropriate writ order or direction not to choose BEd candidates eligible for the post of primary level teacher in schools under RT Act 2009 without passing NCT prescribed this course before appearing in TET examination. This relief has already been granted, and the BEd candidates have been held ineligible prospectively. The appointment management kindly noted that the appointments of the BEd candidates who have already been appointed, subject to the condition imposed by the Supreme Court, their appointments have been protected, and it is held to be ineligible only prospect. Now, relief 3. That the Honorable Court may kindly please to grant liberty to the state government to treat only BSTC candidates as eligible for appointment on the post of primary teacher on account of availability of adequate number of sustained teacher or to give them preference and weightage in the selection process of primary level teachers above said BEd teachers who are not possessing adequate training and qualification for working as primary teacher to teach students in class 1-2. This relative also becomes instructors with their appointment. Now next, to this honorable court may kindly be pleased to the extent that the same relief to the present petitioner as has been granted by Honorable Rajasthan, well, this has also become important. That the Rajasthan High Court has declared the NCT regulation as illegal.
Yes.
And then to set aside the impugn column 5, Malaks have already addressed to that, and this has become infectious because in view of the declaration by the honorable. Now, as far as this petition is concerned, nothing survives in this petition after appointment of these petitions. And this we are not saying today. If Malak should recollect, we have been saying it right from the beginning that after that appointment, this petition has been rendered. Now Malak should kindly come to the order passed by the honorable. Mr. Patwalia has already read this paragraph, but I will just once again I reiterate that because there is a very fine aspect involved in this. Can you see page 7? Every word has a meaning, and as the law says that there is nothing which can be termed as superfluous. Please have a look on page 7. As it appears that a large number of candidates with BEd degree had already been appointed on the basis of eligibility criteria specified by the educational authority, we do not think it to be equitable to affect their removal. We accordingly hold that the judgment delivered by this bench on 11 August 2023 shall have prospective operation. But prospective operation of this judgment, now here onwards, please see. But prospective operation of this judgment shall be only for those candidates who are appointed without any qualification or conditions imposed by any court of law, to the effect that their appointment would be subject to final outcome of the case, which might have been instituted by them. It's institution by them. And this word has got a meaning. Why not it is said, like, please see, number of cases when the petitioner files a petition before your lordship. He makes a prayer for interim relief. Sometimes my lords permit them, grant them that interim relief, but my lords also specify that their relief, which has been granted as an interim measure, will remain subject to outcome of the writ petition. And it's not only that my lords go to the extent of saying that no equitable flow in their favor out of that interim order. This situation is like this, that if a BEd candidate had gone to the court saying that we have been selected, yet the government is not giving us appointment, and then the court would have said that grant them appointment, court would have directed the state government to grant them appointment, but their appointment will remain subject to outcome of the writ. The situation is like this here, that the Supreme Court says that the proceeding instituted by them. Now, here is a situation where I pointed out to your lordship. Advertisement is issued on 6/1/2020. Writ petition is filed on 13/6/2020 after participating in the process. The interim order is passed at our back. We are not participating in the proceeding at that stage. So there is a difference now that if these proceedings were instituted by these BEd candidates, and if this interim order was passed, and their instance, it would have a different connotation. Then, the interim order passed in a petition which is filed at their back, and Supreme Court has not used. It could have been left like this, that if any what was the necessity of adding this word, that they might have been instituted by them. It could have been said only that the final outcome of the cases which have been instituted. But the Supreme Court has used that word, the word. Therefore, my submission is this one, that makes a difference. That the appointments were, firstly, we say that this Kesri Nandan's case, But this interim order was passed in the Kesri Nandan's case, which has already been rendered in process. Now, second aspect is this, that even if it is assumed that this interim order survives, even then now this interim order is not passed by on a petition filed by the candidate of BEd category. This is the petition filed by the DLF candidates. Now, the learned advocate general has already pointed out to your lordship the order passed by the Calcutta High Court. And the Calcutta High Court has very categorically said that because there is nothing to adjudicate now. As far as this aspect is concerned, Supreme Court has said that this is the order. And now this order has to be implemented and everybody has to implement the order as per the letter and spirit as per the direction passed by the Supreme Court. Therefore, my submission is this that.
So the petitioners in these, the first case and the second case, petitioners are diploma holders. And in the third and fourth and all.
Petitioners in the first case, also they are also the DLF.
They are diploma holders.
Yes, they
Yeah, they're diploma holders.
Diploma. Yes.
And what about third and up till?
Well, they all are diploma.
All are diploma.
All are diploma. That is what I say. That
All are diploma holders. All of
There
them.
would be no cause for the BEd candidates to come to court, Manoj. It's obviously only the diploma candidates will come to court. This is such a twisted interpretation. If you see that, if the BEd candidate had come to court, he will not get a protection. That is the suggestion here. Because otherwise everybody else gets
In
protected.
two courts,
but
the
a
BEd
candidate who
candidates
comes to
went.
court will not get a protection.
BEd candidates
These
went to
are-
court in Rajasthan and BEd candidates went to the Supreme Court in Chhattisgarh.
This was a Madhya Pradesh application in the Supreme
Was
Court.
for the simple reason that the Rajasthan
Let-
government did not
let-
accept government's 2018
let-
notification because
No,
Rajasthan
please,
government did
Gillial
not
complete.
include the BEd in the
Please,
exam.
Please let Mr. Gillial complete.
Yes.
Yes.
My submission is this. The order passed by the Supreme Court has to be read in that respect. And with that alone,
So according to you, all these protection is only to BEd appointees.
this protection is
To BEd appointees.
to be appointed now because there are now the conditions Supreme Court has imposed, firstly that the judgment applies prospectively. So the appointments made they are already protected. The only matter was that there should not be any order passed by the court subject to outcome in the proceeding filed by them. There is no proceeding filed by them. Otherwise, there was candidacy. This could have been left by without adding this term then.
All these conditions imposed relate to people who are BEd and were appointed and then approached the court.
Yes.
Did not.
In some states, not BEd.
These conditions apply.
That would never happen.
In some states, the rules did not permit BEd
This
to
is only
complete.
about
For
Madhya
example,
Pradesh.
Rajasthan. Rajasthan rules made BEd ineligible.
Rules permitted BEd.
Here, MP rules permitted.
Yes.
Rajasthan rules did not permit. So Rajasthan, the BEd candidates went to court and got an interim
What I
order
said.
saying that you can participate in the selection process.
This entire clause is an exception to the
In
protection.
Chhattisgarh,
It's an
kindly
exception to
don't
the
interject,
protection and
please.
must be
In
read as such.
Don't interject. In Chhattisgarh,
You also
the
interjecting.
court held that BEds are not
It's an
eligible.
exception to the
So
protection,
the
my
BEd
lord,
candidates
and it
went to
must
the
be read as
Supreme
that.
Court and got an
Otherwise,
interim
the
order.
BEd candidates would have the protection, provided, however, that there was no order. Otherwise, they have the protection regardless of whether they have
not
a
in two
petition or an
states.
interim order or
In
anything.
two states,
There's
the
no
BEd
exception at all.
candidates had gone to court.
The entire law
In
is struck down and they
Rajasthan
get all
and
the protection.
Chhattisgarh.
There was no disqualification as far as in the normal
Lords,
the
we can't
Mr.
lose
Patwari
sight
must
of
have read
the
to the court
fact,
about what he argued in Supreme Court.
my lords, we can't lose sight of the fact that Rajasthan High Court had already struck down that qualification and the advertisements came after that.
Okay.
Let Mr. Gillial complete, please.
Aspect is concerned, we need not to go into that now. The Supreme Court now what has said now it's not immaterial now. The Supreme Court said that our judgment applies prospectively. Being there by the decision of the Supreme Court, the BEd candidates are not to be treated as eligible, and their appointments have been protected. the rules of Madhya Pradesh, now they permitted the B.Ed candidate, the as the rule existed at the time of issue of advertisement, the rules permitted the B.Ed candidates.
No, rules permitted the B.Ed candidates also to be eligible.
Yes,
Also,
yes, also.
besides diploma.
Correct. Diploma in B.Ed. And also, please see, it has been always been said that if these seats are given to B.Ed candidates, what will happen to B.Ed candidates, because they can only go for the primary teacher's appointment and they have no other avenue left over. This is absolutely incorrect. Please go through the rule. Rules, Malon, they permit the B.Ed candidates not only to participate for primary teacher, but they are also eligible for middle teacher. This has all, Malon, this will not be pointed
The
out.
relevant rules are on record? Not.
P1.
P1. In which case?
The advertisement is P1.
Well, this 2018 statutory rules, Malon, it could need Malon, it can supply.
No, in which case?
Well, these rules are in Kesri Nandan's case.
First case.
First case.
Yes.
These rules permit Malon that B.Ed.
Which is the relevant column in that schedule?
Rules are.
This is
Column 5 of schedule 3. That's what our prayer was for.
P1 is within Kumar. 595. My lord, P1 in both the cases.
Malon, please see room, page 17.
Column 5 schedule.
71 or 38?
No, it's not 17.
38.
Or it is rules are in Hindi.
38. Page 38.
Page 30. Page 38. And in these rules, the what the nature of
कम से कम 50% अंकों के साथ हायर सेकेंडरी अथवा इसके संपर्क
Malon, please see
अथवा 50%.
Athwa is or.
अथवा 50%.
Athwa is or.
Athwa. Yes. Schedule 3, Malon, schedule 3. Yes. माध्यमिक शिक्षा.
प्राथमिक शिक्षा का है ना ये?
प्राथमिक शिक्षा के लिए प्राथमिक शिक्षा yes. What I was trying to point out is that DLED candidate is not only eligible for प्राथमिक शिक्षा, that is the primary teacher, but they are also eligible for the middle teacher, madhyamik शिक्षा.
No, we are not concerned with middle madhyamik teacher.
It has been said, Manoj, it has been argued that if the DLED candidates are deprived of their opportunity of appointment as a primary teacher, they have no other avenue open to them. Because they cannot apply for madhyamik शिक्षा and uच्च madhyamik शिक्षा. That is incorrect.
No, we are not here to adjudicate.
Yes, that is
Everything has been done by the Supreme Court.
Yes.
We can't enter into that field of adjudication.
Now, प्राथमिक शिक्षा की qualification, Manoj, please have a look. प्राथमिक शिक्षा. Now, it is Manoj, कम से कम 50% के साथ हायर सेकेंडरी अथवा इसके साथ प्रारंभिक शिक्षा में 2 वर्ष का डिप्लोमा के साथ अथवा 50% अंकों के साथ स्नातक अथवा शिक्षा स्नातक B.Ed. Now it is B.Ed. शिक्षा स्नातक भी बैचलर इन एजुकेशन B.Ed. जिसने राष्ट्रीय अध्यापक शिक्षा परिषद मान्यता प्राप्त संस्था से स्नातक की उपाधि प्राप्त की है, उस पर कक्षा 1 से 5 तक पढ़ाने के लिए अध्यापक के रूप में नियुक्ति हेतु विचार किया जाएगा। क्योंकि अध्यापक के रूप में एक व्यक्ति को राष्ट्रीय शिक्षक के रूप में नियुक्ति होने के 2 वर्ष के भीतर राष्ट्रीय अध्यापक एवं शिक्षा परिषद द्वारा मान्यता प्राप्त प्राथमिक शिक्षा में 6 महीने का एक सेतु पाठ्यक्रम आवश्यक रूप से पूरा करना होगा अथवा कम से कम 45% अंकों के साथ हायर सेकेंडरी अथवा इसके संपर्क अथवा राष्ट्रीय अध्यापक शिक्षा परिषद मान्यता मानक एवं क्रियाविधि विनियमन 2000 के अंदर प्रारंभिक शिक्षा शास्त्र में 2 वर्ष का डिप्लोमा अथवा कम से कम 50% अंकों के साथ हायर सेकेंडरी अथवा इसके समकक्ष तथा प्रारंभिक शिक्षा शास्त्र में 4 वर्षीय स्नातक उपाधि B.Ed. अथवा कम से कम 50% अंकों के साथ हायर सेकेंडरी और इसके समकक्ष शिक्षा स्नातक विशेष शिक्षा में 2 वर्षीय डिप्लोमा अथवा स्नातक उपाधि प्रारंभिक शिक्षा में 2 वर्ष डिप्लोमा अथवा इसके समकक्ष आरक्षित वर्गों जैसे अनुसूचित जाति जनजाति अन्य पिछड़ा वर्गों तथा निःशक्त व्यक्तियों के अभ्यर्थियों को सरकारी अंकों में 5% अंक की छूट दी जाए। So
B.Ed was added
B.Ed is also there
as one of the alternative eligibility criteria.
Lord, now
And this was struck down. This has been struck.
Now it has been.
I'm sorry to interrupt, my lord. That has not been struck down. Your lordships will have to strike it down. It's the Madhya Pradesh rules. Nobody else has struck it down. In terms of Supreme Court's finding, your lordships will have to strike it down formally. That's prayer 7.5 of our writ petition. Nobody has struck it down so far. Your lordships will have to strike it down.
And what happened in Rajasthan?
In Rajasthan, it was the NCT notification, my lords.
Rajasthan,
The underlying one, that was struck down.
Rajasthan, the rules did not permit BEd to
The rules did not
compete.
permit, so there was no challenge to the rules.
Rajasthan
The challenge
rules
was
did
to
not
the
permit
NCT
BEd.
notification. And the court in
Rajasthan
fact
rules did
held
not
over there
permit.
that despite the Rajasthan rules not having been amended in accordance with NCT, you had deprived BEd candidates from taking part. So there the Rajasthan High Court said you should have allowed BEd candidates to take part until the stage at which the NCT notification was formally struck down. But
So
here the fact
Rajasthan,
that
what happened, my lord, the Rajasthan rules did not allow them. The NCT notification said they are eligible. The advertisement did not allow BEd, and therefore the BEd people went to the High Court saying we should be allowed to
the
compete.
light of washing of this NCT notification,
Yes,
rule also has to be struck down.
correct,
Yes, it
correct,
has
correct.
to.
Now,
Yes.
from now the rule, now once the notification goes, the rule also cannot survive because the court says BEd are not eligible.
Since the mother body of teaching education.
Correct. So therefore the question arises, what happens to people who were eligible under the state rules and who have been appointed? That's the issue. And there our interpretation
That's
is
covered by the Supreme Court's order.
if the BEd people had not gone and secured orders, their appointments would be saved.
That doesn't apply to Rajasthan.
I don't think there is a
that
rocket.
doesn't
My
apply to
lord,
Madhya Pradesh.
frankly, the Supreme Court having struck it down and having held that BEd is not an eligible qualification for the purpose of appointment to primary, the question of anything further does not arise. Because
This BEd.
yes, my lord, so the rule
Yes,
as
it's
it
only
prescribes for, yes,
MP is
it's
the
only,
No,
Only
many states,
diploma.
not. In many states,
Only diploma.
most states, almost all states, except Rajasthan and Punjab, in all states BEd are eligible. Only 2 states they were not eligible.
So make these your lords.
my lords, today the position is this, that they are not eligible. Let us
Yes.
not forget that part. It has been found that their qualification is not eligible. They have to go. The only question is whether their appointments, they suffered a kind of a, my lords, an objection to their appointments, or there was an order that made their appointment subject to the outcome.
On which point?
Lord, on the point of this writ petition.
Because they had participated.
Yes, there are 3 aspects of the case. Firstly, no PIA, my lord, in the matter of service. Number 2, those who have not been arrayed as parties, against them you cannot get any relief. And third, very important is that my lord has been putting right from the beginning question, which is the date of the advertisement, which is the date of filing of the petition. All of them have participated in the selection process, and at the end, my lord, when they said that exams we could fare well, then they filed this petition. So, my lord, letter 3, 2010, volume 10, SCC page 707. That is J. Srivastava versus State of Madhya Pradesh. Come down, Lord. To para 15 of the order.
Yes.
My lord has come to para 15.
Yes.
Very with my lord's information.
Yes.
In para 14 of the however, the main argument by the appellants against entertaining WPC and so is on the ground that a PIL in service matter is not maintainable. This court is of the opinion that there is considerable merit in that contention. It is common ground that dispute in this case is an over-selection and appointment, which is a service matter. In Duryodhan Sahu, Dr. versus Jitendra Kumar Mishra, that is 2010-10 SCC 707, a 3-judge bench of this decision held that a PIL is not maintainable in service matters. This court, speaking through Srinivasan J, explained the purpose of administrative tribunals created under Article 323A in the background of extraordinary jurisdiction of the High Court under Article 227 to 6. This court held if public interest litigants at the instance of strangers are allowed to be entertained by the administrative tribunal, the very object of speedy disposal of service matters would get defeated. Same reasoning applies here as as public interest litigation has been filed when the entire dispute relates to selection and appointment, just like my case. Para 16. In B. Srinivas Reddy, that is 2006, volume 11, SCC 731. And this court held that in service matters, only the non-appointees can assail the legality of the appointment procedure. That is the end of the matter, Lord, in most of the cases. Para 17. This view was very strongly expressed by this court in Dattaraj Nathuji Paware versus State of Maharashtra, that is 2005, volume 1, SCC 590, by pointing that despite the decision in Duryodhan Sahu, PILs in service matters continue unabated. This court opined that the High Court should throw out such petitions in view of the decision in Duryodhan Sahu. The same principles have been reiterated in Ashok Kumar Pandey in a recent decision of this court delivered on peace. Thus, in Banchlal, it has been held that except in a case of co-warrant of PAL in a service matter is not maintainable. Now, para 20. The next point urged by the appellants that they have never been included in the two petitions, even as the orders passed by the High Court had a direct effect on their livelihood, also goes to the root of the matter as it violates the principle of order. Here also, what I spoke to my Lord only in two petitions. Look, please hear me. In one case, I'm respondent. In other case, I'm intervener. Now, para 21. This court in Prabodh Verma versus State of UP held the High Court ought not to decide the writ petition under Article 2 to 6 of the Constitution without the person who would be vitally affected by its judgment before it as the respondents. They have never bothered to make any of us as parties block. So many of them selected. Similarly, this court in Ramar, all these judgments are recorded. And para 23 में, there is another important judgment. Para 23 B. Ramajini versus State of Andhra Pradesh, where selection of certain teachers was challenged without implementing them. This court held selection process has commenced long back, as early as in 1998, and it had been completed. The persons selected were appointed pursuant to the selections made and had been performing their duties. However, the selected candidates had not been included as parties to the proceedings, either in the individual capacity or in the representative capacity. In that view of the matter, the High Court ought not to have examined any of the questions raised before it in the proceedings initiated before it. To that extent, the Supreme Court has gone. The writ petitions filed by the respondents concerned ought to have been dismissed, which are more or less in the nature of a public interest litigation. So, Lord, this is the judgment of Giljesh Srivastava. I have requested my Lord's leader also to show me another judgment. That is called Lord Saroj Kumari, 2017, volume 9, SCC, page 478. Because Lord,
On the same point.
no, it is on the point that they were very happy appearing in the exam, my Lord.
Okay.
Aram se exam hai. Lord, the rules were published, Lord, way back in 612. Taken my Lord, everyone has given the chronology to my Lord. I have also given the chronology in my return. उसमें मैंने तारीखें बताई हैं. हाँ, जी हाँ. ये रूल है 28/6/2018 को एक रूल हुआ. मध्य प्रदेश का रूल 1/7/2018 हुआ. Everyone is very happy. 6/1/2020 primary school teacher eligibility test advertised, and everyone participated peacefully on 5/3/22. After having participated a lot, my learned friend Mr. Vidya said that this WP case in London was filed on 13/6. No, Lord, it was filed on 16/6. On 16/6/2020. कोई बात नहीं, एक मिनट का फर्क। So 5/3/2022 को they participated in the eligibility test, knowing fully well that along with me these BEd candidates are also appearing. I'm representing all those BEd candidates, Lord, who have been selected, appointed, they are working on the basis of this advertisement, and these candidates were very happy. So, Lord, what Saroj Kumari says, Saroj Kumari is absolutely clear on this topic, not para 4. The main ground urged on behalf of the appellant is that respondent number 1, having taken part in the selection process, could not be permitted to challenge after she was unsuccessful. Now, Lord, para 5, we only one sentence that makes the position clear. Para 5 में in G. Sarma versus University of Lucknow, the petitioner, after appearing in the interview for the post of professor and having been not selected, pleaded that experts were biased. It was not made. Now, Lord, para 8 is important. Ramesh Chandra Shah has been quoted with approval in Saroj Kumari's case. Ramesh Chandra Shah. That is also 2013, volume 11, SCC, page 309. Saroj Kumari का case.
Yes, yes.
इसको quote किया है, sir. I would like to read with my lord's kind permission. Para 8, Lord.
Yes, yes.
Para 8 में para 24 is quoted. In view of the propositions laid down in the above noted judgment, it must be held that by having taken part in the process of selection with full knowledge that the recruitment was being made under the general rules, the respondents had waived their right to question the advertisement or methodology adopted by the board for making selection, and the single judge and the division bench of the High Court committed grave error by entertaining the grievance made by the respondents.
Not Mr. Rupra, if I rightly remember, maybe I'm wrong, that on this point there was some difference of opinion in the Supreme Court itself, and it was referred to a larger bench. Some recent view has come or not?
No, not that. It might have been distinguished. I don't think it is over because
When can a person who participated can still challenge or not challenge? To what extent he can
you have
challenge?
to vent your grievance before the commencement of the election. You have to, because when I was appearing for the radio deputy, I used to use it because people used to come after the selection process. Now, Lord, the most important thing is that, Lord, all these questions regarding whether BEd, I am representing those BEd candidates who have been selected, appointed. They are working. Now, Lord, as far as KC Nandan and Rohit Kumar, this case in the petition is concerned, it goes because of not this judgment which I said, Lord, Srinivasa. Because, and as far as the other petition is concerned, even in that law, they have not, my Lord, bothered to erase any of the selected candidates. Everyone knew that the selection and the appointment had been done. Lord, way back, appointments of the interveners was issued on 30/3/2023. उसके बाद सब petition पेश की. Then why not make any of them the parties? No, I will not make them parties, but they are. Now, Lord, my Lord,
No opponents are made when the petition is filed.
he made one point. I want to reiterate that. That is it. That, Lord, that there may be many cases in which BEd candidates might have lost in high courts. I want to make that. Many candidates, not BEd candidates, might have lost in the High Court. Then they went to Supreme Court. Supreme Court would say that no, your appointment is subject to the final decision of this SLP. So, in a petition filed by them, if their appointments are subject to the final decision, that is what the Supreme Court judgment says, Lord. Everywhere they say their appointment would be subject to final outcome of the case, which might have been instituted by them.
Yeah.
We have not instituted any case. State of Madhya Pradesh was very happy to entertain BEd candidates. We participated in the selection process. Strict interpretation, exact interpretation of the.
That Mr. Gildea has submitted.
Yes, sir. I adopt his argument and the argument from my learned friend, Mr.
May I respond to these arguments, Suraj, for a minute?
You want to say something?
Yes, I just want to respond to two things. One,
You are appearing
on
for
the
me.
fact that we didn't.
All these arguments, all these arguments, all others, Lord, except Vipin Kumar Dwivedi, are not worth considering. That is my most.
बट मेरा क्वेश्चन सिर्फ इतना है, ऑनरेबल सुप्रीम कोर्ट ने साफ कहा है कि दो सेट के बारे में लो। पहला सेट उनका जो किसी भी प्रोटेक्शन को लेकर के वो अपॉइंट नहीं हुए, वो है मध्य प्रदेश गवर्नमेंट। बहुत सारे ऐसे स्टेट जिन्होंने बीएड को अपने नोटिफिकेशन में लिया ही नहीं, तो उन्होंने साफ तौर पर ये कहा है कि जो प्रोटेक्शन के साथ अपॉइंटीज हुए उनको निकाल दिया जाए। मध्य प्रदेश में 11/10/2023 के पहले एक भी बीएड अपॉइंटीज जो है हाई कोर्ट नहीं आया, किसी भी कोर्ट नहीं गया, ना ही किसी कोर्ट ने उसको अपने ग्रांट करके के द्वारा उसको अपॉइंट किया। लॉर्डशिप से तो हमारा ये कंसर्न यहाँ पर लॉर्डशिप की हमें ना तो केसी नंदा से ना किसी चीज इनकी जो है, हमें तो माननीय सुप्रीम कोर्ट ने साफ तौर पर सेट 1 में रखा है, मध्य प्रदेश सेट 1 कर रखा है।
Manoj, can I just respond to what my friends had said?
Yes.
Number one, as far as not making them parties, when we filed our petitions, no appointments had taken place. So there was no question of making anybody parties when we made our when we filed our petitions. Second, all those petitions had interim orders which made it clear that it was subject to the outcome. So we presume that the state, if they are going to make appointments, are going to be informing the people they're appointing that it is subject to the outcome of court proceedings, to the which the state is very much a party at that point of time. Point number 3, repeatedly they have drawn attention to these words at the top of page 8 of the Supreme Court order. Let me just read that again so your lordships have the entire context of it, because they've for some reason decided to amputate that sentence. Let me just read fully that entire paragraph from bottom of page 7. As it appears that a large number of candidates with BEd degree had already been appointed on the basis of eligibility criteria specified by the educational authorities. So this would necessarily have to include BEd as an eligibility criteria for them to be appointed. We do not think it to be equitable to effect their removal. Therefore, this is not considering a Rajasthan scenario at all. We accordingly hold that the judgment delivered by this bench on 11th August shall have prospective operation. But prospective operation, from here the exception starts, where they will not have the protection. But prospective operation of this judgment shall be only for those candidates who were appointed without any qualification or condition imposed by any court of law, to the effect that their appointment would be subject to final outcome of the case, which might have been instituted. These words by them is what they're emphasizing, saying that it could only be if it's filed by the BEd candidates. By them, I would interpret to mean by whoever the petitioners are in that particular case, because the rest of the sentence makes sense, which might have been instituted by them, and such candidates were in regular employment without any disqualification and were appointed in pursuance of a notice of advertisement where BEd was stipulated to be valid qualification. BEd was stipulated to be a valid qualification in Madhya Pradesh, not in Rajasthan. No BEd candidate would go to the court when BEd qualification is given in his advertisement. He would only go when it's not given. Therefore, it is very clear that this petition, this order provides that BEd candidates who had qualifications provided in their advertisement, who had participated and then were made subject to a order of the court, will not have the protection, provided they were appointed prior to 11th August 23. If you're appointed after 11th August 23, there is no protection. That I think even Mr. Patwala will concede. That is the nature of the prospective order.
When were these petitioners appointed?
These petitions, now as far as the interveners are concerned,
30th March 23 and 10th August 23.
Now 10th August 23 is not an appointment. Your lordship may check that. There's not one single appointment which took place on 10th August. It's a notification listing those who would be appointed. So the appointments themselves took place after 11th August 23.
March 2023.
So they are all before the judgment.
Correct. They have all been appointed.
Some of them are
the
before,
judgment.
some are after.
They have all been appointed before
Your
the
Lordship
judgment.
may ask for the list from the state with the dates of appointment.
The data.
Lords, our unequivocal submission is that every single appointment took place after your Lordship's interim order. The minute it took place after your Lordship's interim order, they lose the protection.
August 2022. The result was prepared not well before time and it was declared on 8th of August 2022.
The interim order is 7th July 22, which takes note of the Rajasthan High Court judgment.
Nandan is out now. We are not considering it.
With Vipin Kumar, there was an interim order.
Please, my lords, on the 16th of January 23.
January 23.
16th January 23, much
fact,
before the appointment on
7th
30th.
July 22, 7th July 22 in my case, in Kesari Nandan, your Lordships took note of the Rajasthan High Court judgment and specifically said in view of the above.
You give us that within 2-3 days within this week. Please give us that.
We'll give you a note, my lords, with all that.
Date of appointment. That is all. The
Date of appointment are
My
only
lords,
2 dates.
I had pointed
The
page number
appointment orders
16.
are 30th
Page number
March
16 of the
2023
compilation.
and
Page
10th August
16.
2023.
Mr. Patwalia, to make it easy for the court, it
And,
is the state government
just 1 minute,
affidavit.
madam. And the appointment orders are clear. They are not subject to anything. They are categoric orders of appointment. And
So
they are
court's
not
orders are
only-
categorical. Court's orders make it subject to.
Yes.
Government can't decide to do what it wants on its own.
Yes.
My lords, just to assist my lords, please see page number 16. This is a part of affidavit of the state of MP filed before Supreme Court. It starts at page 13 of the compilation at page number 16. There's also one thing out there. While according to them, 11,583 out of which 2,784 being made on that notification on 10th of August 2023, which they state, they clearly say 284 have been made after 11/8. And they write that they had only issued a notification and that the appointments had to be sent later on, which is mentioned there.
All right, so these first 2 cases, they are diploma holders. What about the remaining? All of them are diploma holders.
My lords, there was no need for the BED to approach the court in Madhya Pradesh because under the existing thing, BED were eligible. So the challenge to that was made by the diploma holders. And my lords, may I just in 2 lines respond to what has been argued? I would respectfully submit that I heard that argument being made on the other side, that whether in person or in representative capacity. Now, in representative capacity, impleadment was filed before Supreme Court on 11th October 2022, where Supreme Court reiterated the same stay of being subject to the orders issued in the petitions in the case. Now, they were aware even at that time, all the BED, and subsequently the BED have filed their impleadments. So, my lords, that argument and showing all the judgments of not being made a party, etc., is actually holds no water for the reason that they have been before my lords, and the courts have held that in any manner a representative capacity is sufficient in these matters.
All right, we are resolving the case and asking the state to file a tabular illustration.
Please, my lords.
Believing that after extensive arguments, the case stands reserved for passing final orders. Next, for the council, the state is directed to file a tabular illustration mentioning the date of appointment of whose appointment?
BED.
Appointment of the BED candidates.
BED.
So date of appointment letter being issued, that would be important. Date of appointment letter being issued, not the notification.
We'll reserve it and wait for yours. That we have.
Grateful, Manoj, grateful.
Very, very grateful, my lord, for the hearing. Very
Point
grateful.
five? Locus. Wait, on what point? What is the point?
They did so far as the player A and B in the repetition are concerned, we find force in the submission of the learned attorney general. But insofar as the player C of the repetition is concerned, it raised an important public issue and involved the interpretation of Article 156 of the Constitution of India. And again, why we do not think that we can rely locus to the petitioner for raising that issue. The honorable apex court.
What is Article 156?
156.
What has that got to do with service matter?
Article 21. A. The right to education.
No, you are talking about Article 156. Hussein, इसका
Article 21A. Currently, fundamental right to the children, right to education. The eligible candidate who secured the BEd degree, they have not qualified to impart the children belong to age 6 to.
that 21A, Mr. Counsel, is children centric.
Yes,
Not
not to do with the teachers at all.
Where is that issue open now?
वो आप दे दीजिए फोटोकॉपी दे दीजिए फोटोकॉपी यस यस
Grateful, my lord.
Obliged, my lords. We are very grateful for very patient.
Very grateful.
Great.
Number 39.
Primary argument.
39
What's 39?
CRC
Yes, Lordship.
paucity of time not possible to hear this case finally just on any Wednesday Thursday in the month of July.
Number 47 कौन बात है? आपको पर बाद में लेंगे. Number 47 कौन बात है?
Plans हो गया है?
टीम ने ऑर्डर पास कर दिया.
कर दिया और इसमें learned counsel for the petitioner informs that the order, final order dated so by which this petition has been disposed of stands complied with. By passing of order under section 14 by additional district magistrate
इसमें पांडुना में
Chhindwara.
पांडुना में ऑर्डर किया. यदि फाइलिंग हुआ तो छिंदवाड़ा में.
एडिशनल डिस्ट्रिक्ट
डिस्ट्रिक्ट बन गया तो वहां पर ट्रांसफर हो गया पीएम पांडुरंग में ऑर्डर
डिस्ट्रिक्ट मैजिस्ट्रेट पांडुरंग ऑन कब ऑर्डर किया
1/3/2024
1/3/24 next view of the above the no need to proceed with this case and the same is consigned to the recording.
Your number 41.33 Sharad Verma.
Report अब है शायद कोई इसमें आइए मूव किया है आइटम 41 वेयर ब्रदर मैं तो कोई ऑर्डर नहीं है इसमें कोई ऑर्डर नहीं है इसमें 2340
फर्स्ट टाइम ही लगा
हाँ फर्स्ट टाइम लग रहा है that the factum of marriage of real brother of the appellant be appellant number 1 be verified. कब है शादी? Ice list 26th 26 तारीख 24/4 fresh cases.
Your number 42 जहाँ से कर दो पढ़ो तो लेते मैसेज
Hello. Objection है इसमें?
नहीं सर ये फाइल
All right. Notice admit IR finally.
करेंगे दिखा
Ignoring the defects of
Your number 43
pages are found to be illegible.
Anil Kumar Golan
Fresh case. क्या हुआ है इसमें? All right. Notice record.
क्या नाम है अनिल कुमार गोलान
Okay.
Your number 44 Gopal Singh
Home guards. Any objection? हाँ तो वो वाला ऑर्डर कर दें interim order. Notice admission admit IR finally.
Your number 45 with connected matters Amrutdev Singh Bagir Vivek Shukla has to be done timely.
Finally. ये स्टेट बार कंपनी का such as past 4:30 will not be possible to hear this case today, which is listed for final order next in motion next week. List in the first week of May. Second week of May.
I have to continue.
I have to continue.
It's part of the doing it.
Thank you, but hello. Hello.
Your number 14 October matter share number 14 GR circuit
ये आपने विड्रॉल के लिए लगाई है किसकी तरफ से है आप 7, 8, 9, 10 only 7, 8, 9, 10 नहीं, petitioner तो एक ही है इसमें। आप किसके तरफ से हैं?
Yes. 14.
किसके तरफ से?
कितना करना 7-8 9 की तरफ से।
अच्छा, ये allow कर दूँ only on behalf of 10.
10 के लिए
10 तो लिखा ही, आपने सिर्फ 10 लिखा है अभी।
आई नहीं।
एक आईए में 10 की तरफ से है, और आईए में 7
Scan नहीं।
IS so and so application has been booked. All of this petition on behalf of 7, 8, 10. After due consideration, IS stands allowed for reasons mentioned. Petition stands dismissed so far as it relates to the next, for as regards the other petitioners, counsel comes from the petition subsists. Yes.
number 22 Amit Kumar Singh.
और this one इसमें माना कि कुछ सैनिकों को जिज्ञासा है, कुछ सैनिकों को निर्देशित करे कि बिना इस बदला प्रदेश के समय कर्तव्य तब कौन बात कार्यालय की दिशा में हम देने दिनांक 3/4/2024 से 21/24 तक सैनिकों के
होमगार्ड्स का मैटर है।
जी
अच्छा,
कर दिया है। कस्टमर से प्रोड्यूस ऑर्डर फाइल कर दिया।
ठीक है, तो वो ऑर्डर कर दो जैसे सब में करता हूँ। नोटिस एडमिट IR फाइनली वो फाइनली मिलेगा। फाइनली जब आप जीतेंगे तब मिल जाएगा, आगे से आपको नहीं करेंगे।
नंबर 22 अमित कुमार सिंह।
नंबर
22
last time none had appeared to the petition. Yet this court adjourned the matter for 3 weeks to enable representation on behalf of the petition. Next part. Today, one appeared in the first round, none appeared less in the second round. Seeing that petitioner is not interested to pursue, dismissed for want of person.
number 29 Anup Gupta.
What is that relation to the respondents?
Mr. Rupra, you have been now permitted to argue before DB1, I've been told.
Yes, yes, from yesterday onward.
So we'll be relieved of all your cases. Here are all the cases in this.
No need for my lord to do this.
Though,
Automatically, they will go appropriate. They are
though we'll be deprived of the privilege of hearing you, but then
My lord,
29.
how privileged to appear in each and every, especially in BB.
So what is 29?
Diary number 4786/2023. With the petitioner is made a party as a respondent because of
तो मोनिका शाह के नहीं है भाई
नहीं,
पार्टी।
दूसरा दे दे, इसी का दे दे। नहीं, उसके तरीके थे।
नीचे में तो कोई पार्टीज का नाम नहीं है, SLPC बस लिखा। यही सब पार्टीज है। तो ये कब लगाया?
ये इसमें लास्ट में देखें, इस पर करेक्ट हो गए और वोट से हो गए
18 साल।
आपके लिए हुआ है।
18 साल के बाद रख देते हैं। Is informed that
नोटिस हो गई है, ये
informed that
जवाब फाइल कर
State Council that the challenge to the
एक बात है,
order.
Not there is no interim order. Will come filing of the appeal does not mean because my lord has given only 60 days time to implement.
It is time to implement.
60 days time, my lord.
60 days कब हुआ है पूरा?
60 days has finished in the month of September. अब देखिए ना, my lord's order is dated.
That was passed in the WTA.
Passed on 13/6/23. So 14/8/23, 60 days complete. So Lord, they can't appear before the High Court, say we have gone to the Supreme Court, now we will not implement it. That's not
There was a delay has been controlled, my lord, notices have been issued, my lord. They are representing their case before the honorable apex court, my lord. Yes, sir. Respondent number 3, 4, 7, 10, 11, 13 and 14 are allotted 4 weeks time for filing counter affidavit. सबका अलग अलग दिया हुआ है. Last page, my lord.
Nevertheless, filing of let my learned friend present any interim order of the Supreme Court or reply the content. Pendency of the matter, I can show rulings. Pendency of the matter before the Supreme Court is no ground for non-implementation of the High Court order. After, because the Supreme Court has already taken the view in my favor on the basis of which my lord passed the order.
You may be technically correct, Mr. Lutla, but the moment we issue contempt notice, they will get an additional ground of arguing on stay there.
Yes, yes.
So-
Because I'm sure they will lose in the Supreme.
So we don't want to give them that ground.
No.
So let us wait for some time.
I'll be very happy if my lord gives that ground. I'll be very happy. Because I don't want Lord hanging like this. Because age is, now many of the employees now, they are also looking for jobs. They have to study, pay a lot of fee for their academics, in which they take the training, physical training. And then
We'll issue notice and then we'll say that it will remain subject to.
notice and let them file reply. Let them file reply with, because and my habitat may be recorded, that filing.
No, but who is responsible for this implementation? Who will implement?
Implement by respondent number 2.
Number 2, let notice be issued to respondent number 2 on payment of PF within 7 working days per entry. Next one.
No, issue notice, my lord, on 2/1/23. My lord has been already pleased to issue notice on 2/1/20. And notice has been paid, that's why my lord tragedy. Are you appearing
For number 2, I think there's somebody. Yes.
They have not filed any reply. They have filed only the application.
Number 2,
They should file reply on.
the application for deferring of hearing of this contempt petition has been filed by the counsel for respondent number 2 on the ground that the order whose non-compliance is alleged in this contempt petition is under challenge before the apex court in SLPC 5203.
5750 में है इनका.
5750 24, which has now been posted for hearing on 18/7/24. Next one. Subject to the outcome in the said SLP, the respondent number 2 is directed to file a reply to the contempt petition. Just in the in the week commencing
22nd of July.
listed when?
ये 18 साल के लिए लगा.
By Saturday.
Yes, week commencing by South.
Number 35,
Lord, that is the case.
Sri Rajesh Kumar Srivastava, Pita Parma.
Item number?
35. This case, my lord, Petitioner has been agreed by the order passed by the High Court in appeal on its administrative file, whereby they dismiss the appeal and without any merit. Then has been given the appellate that anti-associate always comes to merit. And not, there's another point also. Is prepared by. He says ground number 6.2.
So where is the impugned order?
Impugned order is P1. श्रीमती अर्पणा होलकर प्रस्तुतकार न्याय जिला अपना इंदौर में जिला एवं सत्र न्यायाधीश इंदौर के आदेश क्रमांक 505/7/14 जिसके द्वारा श्रीमती होलकर को उसके विरुद्ध संस्कृत विभागीय जांच में विचित आरोप आंशिक रूप से पाए जाने पर मध्य प्रदेश सिविल सेवा वर्गीकरण नियम 1966 के नियम 10(4) के अंतर्गत 3 वार्षिक वेतन वृद्धियां संचयी प्रभाव से रोके जाने की शास्ति से दंडित किया गया है। के विरुद्ध प्रशासनिक अपील 14/8/14 से 25/8/14 को प्राप्त कर अपील स्वीकार करते हुए दंडादेश को पास किए जाने का
अवधि बाधित होने से बाधित होने से लिमिटेशन
अवधि बाधित बहुत ही छोटी।
कब का इसमें कितना पीरियड होता है आपका लिमिटेशन का? 30 days, 60 days?
40 days were completed on 14/8/14.
45 days.
45 days. और third it's this one time has to be decided on dates.
इसमें जवाब आ गया है क्या? जवाब आ गया?
नहीं, जवाब नहीं, अभी नोटिस आया
नहीं, रिप्लाई आ गया इसमें। आइटम 35 ना?
एकदम 35
इसमें जवाब तो आ गया। तो हाई कोर्ट का जवाब है। लेट द हाई कोर्ट काउंसिल कम। Just in the next week, since the issue lies in a narrow compass for hearing and motion. हाँ, तो उसको लिस्ट कराइए आप लोग। रिक्वेस्ट करके लिस्ट कराइए ना, तो इसके साथ क्लब कर देंगे। लिस्ट कराना पड़ेगा आपको। हाँ, जहाँ भी कोर्ट स्लिप लीजिए।
Right.